Hello, everyone, and welcome to Kevin's Corner. This is Kevin Horner of Galligan Manning. Thank you all for joining us, and thank you for joining us in the past few weeks. We've had an awful lot of views and gotten some good feedback on all of our presentations. So I thank you all for that, and I'm glad you're here with us today. If you are tuning in for the first time, this is Kevin's Corner, my chance to talk about a few topics either related to estate planning or estate administration or elder law. And it's an opportunity for me to hit a couple of just quick highlights and for you all to ask questions or get specific things answered without having the formal meeting to do so. So with that, I want to jump into the topic for today, which is going to be estate planning for non-traditional families. So everyone has, in some way, shape, or form, run into the non-traditional family, I'm sure. And a lot of the reason why is just the basic way society and statistics have kind of gone. People have often heard the statistic that more than half of marriages actually end in divorce. I saw recently in preparation for this that actually that number is trending downward, and actually it's probably a little bit less than half currently. That being said, the marriages might be lasting more, but there's also less of them. People are not marrying, and essentially just the dynamics of the family have changed over time. Why is this relevant for estate planning? Because the basics of estate planning are pretty much all set up on the concept in society of the quote-unquote traditional family to the extent that exists. So I want to just talk about three things to think about if you don't have the simple spouse, two kids, one boy, one girl scenario that we're all kind of envisioning in a perfect, simple family scenario. But like all of us, you have a real family with all of its issues. So a couple of things to think about. First and foremost is what I started to say is that the law is based on traditional family expectations, not on what you actually have. So first, in every state, if you don't have a will, if you don't have a trust or something saying where you want all of your assets to go when you pass away, the state has an answer for that called intestacy. It's whoever your beneficiary is if you don't actually say. Most people assume your spouse is automatically your beneficiary. That is often not true, especially in non-traditional situations. So say, for example, the most common one by far is the blended family, where you have kids of a prior marriage and then a second marriage. This one comes up all the time. The surviving spouse always assumes they're entitled to everything, and in fact, that's not true. Depending on which state and which property you're talking about, they might have some rights, probably, but certainly not all of them. And they find that out really when they come in to figure out if they need to do anything in their late spouse's estate. The easiest way by far to cure that is to simply have an estate plan in place saying, I leave everything to my spouse as opposed to my kids from the prior marriage. By that same token, you have situations where, let's say you want to provide for those kids as opposed to the second spouse. It's a later in life marriage and the surviving spouse is already well set up financially. Maybe you even had prenups or something like that where you've gotten your pot and they have their pot, and that's the way you want it. But you want them to still somehow benefit. That's perfectly fine. What you can do is, in that scenario, do a marital trust where you have a trust set up so that you make sure that second spouse gets some benefit. Maybe they can use the income or some of the money from that trust during their lifetime, but when they pass away, it doesn't go to their respective children or their respective beneficiaries, but back to your kids if that's what you want. It's a very easy way of making sure you take care of your spouse, but at the same time recognize it's kind of yours, or that's usually how people say it to me. It's yours and theirs was theirs, and you want it to go back to your side of the family. Very basic thing to do, a marital trust. And then sort of the last one to think about is maybe the even less traditional planning where there's no marriage at all, and it's just partners. They never marry. There's no common law, whatever state they're applied in, no common law marriage, nothing like that. They just simply are together. They intend to stay together, but they're never going to get married. I already said at the beginning that state law is generally based upon the concept of an expectation of a traditional marriage. Get married, have the two kids, maybe even the dog. Should turn out the dog, right? And they don't ever have that. So there is no automatic designation of the spouse because there's no spouse to give it to. All you really need to do in that situation, but it highlights the importance of it, is just make sure you do an estate plan, because it's as though you were never married, because you're not. It's making sure that if you want to go to your partner, then you designate your partner. and you designate the children of that relationship afterwards, or whomever it is. The key to all three of these scenarios is, as long as you affirmatively plan, you actually do something for it, and not just beneficiary designations, but have a will saying where you want it to go, have a trust, etc., then all of this thing can be planned for. Okay? So I kind of went through a little bit faster than I intended to, so I'll just kind of rehash them very, very quickly. But one, if you don't have the standard family, there's a good chance that your spouse is not automatically the beneficiary of your entire estate. Easiest solution, have a will, use the will to actually have everything go over to them when you pass away. Secondly, after that, a lot of times with stepchildren, you want to provide for your family even in your estate plan. Very easy to do. Set up a trust, usually called a marital trust, where your spouse can benefit from it during their lifetime, and then whatever is left over goes back to your kids. And then third, if you don't actually have a marriage, you can't assume it's going to go to the right person. Just make sure you have your full estate plan. Do the will, do the trust if that's what's appropriate, do powers of attorney, healthcare powers of attorney, all of the designations that you need so that it gets to the right people. So just to rehash one last time, even if you're married, it doesn't automatically all go to your spouse if you have a non-traditional family. 2, you can still provide for kids through a marital trust. And then 3, if you're not married but have someone you would treat similarly to that, make sure you have the estate plan to get the assets to them in the right way. So thank you all very much for attending. I know I said a lot, and there are, of course, a greater variety in families than even I can describe in these. These are just 3 very common scenarios we see with 3 very easy solutions, quite frankly. So if you have any other scenarios or other questions you want answered, by all means, you can give us a call. You can go to our website, galliganmanning.com, and send an email. I look forward to any questions, any feedback, and I thank you all for attending.